Good morning. Are you Stephanie Martin?
Yes, ma'am.
Give me just a second, please. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, Ms. Martin, and cause number 20. Let's see, where am I start? Which one's being dismissed?
It's ending in 247, Judge.
And cause number 24, DCCR 0248. You're charged with the state jail felony offense of possession of a controlled substance from October 1st of 2023. The indictment alleges that you were previously convicted of possession of a controlled substance on August 24th of 2015. And then after that was final, you were convicted of possession of a controlled substance April 11th of 2016, and also convicted of fraudulent use of identifying information on April 11th of 2016. And how do you plead to that charge?
Guilty.
And are those prior offenses true?
Yes, ma'am.
And then in cause number 23, DCCR 1850, you're charged also with the state jail felony offense of theft with previous convictions. Well, not also, but in that case, that's what you're charged with. And that's from July 14th of 2023. The indictment alleges you were previously convicted of theft August 14th of 2001, March 15th of 2006, September 8th of 2014, August 24th of 2015, April 11th of 2016, July 31st of 2018, January 28th of 2019, and then the indictment alleges those three prior other offenses of the possession of a controlled substance in two cases and that fraudulent use of identifying information. And how do you plead to that charge?
Guilty.
And are all of those prior convictions true?
Yes, ma'am.
In cause number 250376, you're charged with the state jail felony offense of theft of property with previous convictions. This offense date is from February 7th of 2025. It alleges all of those same prior theft offenses as well as the same prior state jail felony offenses. And how do you plead to that charge?
Guilty.
And again, are those prior convictions true? And how do you plead to that charge?
Guilty.
And again, are all of those prior convictions true?
Yes, ma'am.
In each of these cases, did you enter your pleas of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each case because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Martin is not competent?
No, Your Honor.
All right, Ms. Martin, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. Find you guilty of the state jail felony offense of theft with prior convictions. Find all of the prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 250376, also find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Find all of the previous convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 1850, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions. Find all those prior convictions true, sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit for that on that sentence for any time that you've been in custody that the law gives you the right to receive. And clause number 24, DCCR 0248, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find all of those prior convictions true, sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will all run concurrently, which means together at the same time.
So are we doing all this?
All of it runs at the same time, yes ma'am. I will also sign a dismissal in 24 DCCR 0247 as part of that agreement. So there's another possession case out there that Beaumont PD has, but that they haven't, either the labs haven't been done or whatever, it hasn't been indicted yet. What they're saying is they're not going to pursue that case. So it will not be indicted. You're not going to have to come back here and take care of that case. It's kind of like it's being dismissed before it really gets indicted. Does that make sense?
Yes, ma'am.
Okay. Did I print all 4?
Yes.
All right, so I'm going to hand you, in all 4 of these cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Yes, ma'am.
I'm sorry. Can I say one? Those are my kids right there. Can I just tell them bye?
From here, yes,
I'm
ma'am.
sorry I let y'all down. And I will see y'all when I come home, okay? You good. I love you, miss. My birthday tomorrow. I love you.
So, Ms. St. Clair, the thing to do is to take advantage of any opportunity you have while you're in custody so that when you do get out, you can be a part of their lives, okay?
Yes, ma'am.
All right.
See y'all in 2 and a half. I love you.
Morning, sir. You're Lester Ballard. And Mr. Ballard, in cause number 24, DCCR 1882, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 8th of 2024. Your indictment alleges that you were previously convicted of the third-degree felony offense of stalking on June 11th of 2007. And after that was final, you were convicted of the third-degree felony offense of assault with bodily injury on a family member, and that's from October 22nd of 2010. What that means is that if you go to trial and you're found guilty and those 2 prior convictions are true, then you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? For a cap of 5 years in prison, which means you would be leaving your punishment up to me. I couldn't give you more than 5 years if I accepted that plea agreement. I could give you 5, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide if you're guilty or not, and then let them decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
And when I was speaking with him, I didn't want to sign it until I spoke with you.
Okay.
Sign it, he was going to tell you that I rejected it.
Okay.
That's why I wanted to speak with you to get a clearer understanding.
Okay. All right. What do you not understand?
I wanted to get a clear understanding of speaking with you about it.
Okay.
Because there was somebody that pulled a gun on me.
So hang on. Here's the thing. I'm not going to talk to you about the facts of the case. All right, so that's what your attorney's for. That's what a jury's
I relayed
for.
all this information to the district attorney's office, and they're aware of all this stuff.
Okay, so Mr. Park, you've told him these things about what happened. He's told Mr. Smith. Mr. Smith's made his offer. You can either take it or let a jury decide. We're not going to negotiate. I'm not going to get into the negotiations because that's not the time to do it. I also don't want you to say anything on the record right now that would potentially hurt you later in a trial. Okay, so what I need to know is, do you want to accept that plea agreement for a cap of 5 years, or do you want to let a jury decide? If you didn't do it, that's what juries are for, right? Okay, so you can't, if you plead, here's the thing, if you want to plead guilty, you're going to swear under oath that you're telling the truth. I'm going to ask you the question, are you pleading guilty freely and voluntarily? Are you pleading guilty because you did it? If you didn't do it, then that's what a jury's for. So do you want to reject that offer and go to trial?
I was asking about the speedy trial as well.
So we do not have any type of backlog here in this court. Cases are getting tried as quickly as we can possibly try them every single week. So every trial gets as speedy trial as I can possibly give it. All right?
Reason why I asked that, because I'm around people who say they've been there 2 years and counting with maybe some.
There are different things in different cases that cause them sometimes to go longer. Sometimes it's a different court. Sometimes it's just the facts of the case. Sometimes it's DNA. But I can assure you that we will do it as quickly as we possibly can. All right? So do you want to reject that offer and go to trial, or do you want to accept the offer?
In between now and whatever the speedy trial
I don't get to,
situation is.
no, here's the thing. After today, if you place your case on the trial docket, my trial docket isn't somewhere where I put cases so that there's some more negotiation or you get a lesser deal later. Today's the day if you want to take a deal. If you don't, if it's on the trial docket, your choices are either going to be to plea open to me or to take it to trial. Because that's how I keep my trial docket moving, so that it doesn't get too big and people aren't waiting on trial for a long time. Mr. Smith, is there any reason to believe that offer would change? Okay, so the offer is what it is. Take it or leave it. What do you want to do?
I'll take it.
I want to make sure you understand what you're going to do and say on the record, however.
Yes.
Okay.
There's no, so I might as well take it.
No, there's no might as well take it. Either you did it and you're guilty of it, or you let a jury decide. You're not going to stand in front of me and say, I didn't do it, but I'm just going to take a deal. It doesn't work that way. I can't allow you to do that. Go talk to your attorney about it, and y'all let me know what you want to do. I'll hold it for now. All right, sir, are you Lentavius Strickland? And Mr. Strickland, you were previously in court, entered pleas of guilty to evading arrest or detention with the use of a motor vehicle, as well as unauthorized use of a motor vehicle. I've received the pre-sentence report and reviewed that. Has everyone had an opportunity to review that?
Yeah, Your Honor.
State has, Judge.
Are there any additions or corrections?
I'm aware of that.
Not from the state, Judge.
In addition to that, I have reviewed your jail incident reports. Everyone's been given a copy of those as well. Have y'all both had an opportunity to review those?
Yes, Judge.
I have, but I don't remember.
4 fights.
Yeah.
Oh, yeah.
You like to fight, don't you? You don't? You don't? Okay. I can tell you that I have people in front of me all the time, and they're not doing what you're doing. Things going on, specifically finding places to fight, getting in the bathroom to fight so you can't be caught and all that kind of nonsense. How old are you? 19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days up front. I don't know that jail necessarily is as useful as potentially something like ISF, cognitive track, because of its age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going, you're not going to be. The conditions of your probation are always up to me. So I can give you what I want as a condition, anything that makes me feel like it would be helpful for you, helpful for the community. So what I'm going to do at this time is find that you previously entered your pleas of guilty freely and voluntarily. And cause number 24 DCCR 2440 finds sufficient evidence to find you guilty, and at this time, follow your agreement and finds you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0209, find sufficient evidence to find you guilty, and at this time, follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison, but probate that. You'll be on probation for 5 years in that case. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then going to prison. Do you understand? If you get in trouble now that you're on probation, if you get in trouble in the jail, get in a fight, if you get in trouble at ISF and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go to prison, okay? All right, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker, okay? Good luck to you, sir. Take advantage of this opportunity. You can go back with the bailiff.